limits of criminal law, and I am placing this session on, I am speaking on positive obligations in criminal law. How many of you have heard this phrase, positive obligations in criminal law? This is a phrase which is generally used in the context of human rights instruments, and certain liabilities are then are restricted, are then made on the part of the state. So in criminal law, generally we have been listening since morning and since last day that the criminal law has not to be very repressive, or it should not be punitive. We are talking about a positive criminal law. Now, positive criminal law is not about merely punishing the people. It is also about conferring certain rights on the people. So my formulation of criminal law is essentially in this paper is the criminal law also confers certain rights on the people. Most of the cases we think law creates liability, but law creates certain rights also. This is fantastic, formulation. Positive obligations means entire conditioning of a student in criminal law is like that. An act is always punishable. We always look at in criminal law the acts are punished, and there are certain obligations which are created by the same law where the citizens are expected to act proactively in certain situations, and where you fail to do those proactive things, you become liable. So criminal law is an expectation also to behave in a certain way, because law is a framework for conduct basically. So not always through preventing or punishing the act, but also expecting certain positive obligations. So what is positive and what is not? Positive means when a thing has not yet happened, you are in a situation you are likely to. So how many of you have seen Michael Sandel's lectures? Many of you must have seen. So Michael says that you are standing on the corner of a tunnel, a train is coming, you want that to be stopped at the end of tunnel, 5 people are working, and there is a fat man standing at the railing. You can push that fat man, stop that train, save the life of 5. What is required. So in such a person is drowning in a lake, you are passing by, you are a good swimmer. What is the expected conduct? So there are duty situations which are created in this law. Criminal law is never read like that. I am giving a perspective. So I'll take you through certain slides which are very interesting. Positive obligations is about respect for, this is you please read this Lyra Lazarus paper. He's a great disciple of Ashworth, and he has written this paper in response to Ashworth theory on positive obligation in criminal law. And he's saying respect for human rights and the pursuit of safety and security are the reduction of harm and reduction of the risk harm through the criminal law. Nature of criminal law we have to see. I have just mentioned we are talking about criminal law. What kind of criminal law we are talking? A reactionary criminal law or a positive criminal law? So moral, social and political foundation of imposing positive obligation. Why positive obligation? So at places like suppose you are in possession of information that your house is being misused for some criminal purposes, or you are aware that a child is being sexually exploited, or you are knowing that a person is possession of some explosives which he may use at any places, and you do not act. You don't do anything wrong, but certain omissions are caused in the process. So omissions we have forgotten. You'll never find any debate happening in this country on omission. We are so act conscious people. We have thought only criminal law in terms of act, but criminal law is also in terms of omission. And omissions are your positive obligations. Why omissions? In no class I am telling you in criminal law, no teacher teaches the moral, social and political foundation of imposing political obligations through omissions. Why? You ask any student what is the jurisprudence and philosophy behind positive omission. And in certain situations, it's not the individual alone who is under positive obligation. It is the state. The state is also under certain positive obligation. Like it is the state duty to prevent the harms against the citizen. And therefore, a duty is cast on the state to take necessary measures to see the well-being of women, children, citizens, your safety, your security. So state is liable. So therefore, human rights framework relies on positive obligation. So suppose United Nations framework or European framework, they are expecting certain duties to be performed by the, and there are reciprocal duties of citizens. So criminal law, the citizens are not always on the receiving end. They are also have a proactive role to play. So are we thinking we are defending ourselves against criminal law in most cases? Criminal law is outreaching, it is doing that. But what are you doing in criminal law? That is the whole issue. So let us see what Ashworth says. So two types of obligation Ashworth is talking. Individual, first is individual. Companies and other organizations, they are under certain duties. So companies they have to comply with so many things, like every company is liable to create a mechanism to see that women are not subjected to any harassment. This is a public policy now for every company or organization. It's not that there are cases of harassment in that company. But these are the positive obligations on the company. Positive obligation towards environment protection, towards several kinds of welfare things. Second, the positive obligations which rests with the state. Duty to have in place laws that give adequate protection to the rights. So it is the duty of the state. Duty to justice and duty to protection. This is, so the state is being obligated. Because when we debate criminal law, we have to debate in terms of the liabilities which this law is likely to create for the individual and for the state. Omissions. So I am, in this presentation, I am reading positive obligations through omissions. So according to my contention, that omissions are a form of, very expressed form of positive obligations located in the field of criminal. Omission means a failure to act. That means when a person is bound to do act, he omits certain thing and deliberately neglects, it is called omission. That is a simple definition. And the principle that Ashworth propounded, when omission becomes criminally liable. So if you do not act, so it is not your voluntary choice. You are under legal duty to act in certain situations. We have to see whether all omissions which are formulated in the criminal law are those where a legal duty is created. So suppose under say POXO, it is the liability which is created on the citizen if, despite knowing an instance of sexual exploitation, if he or she fails to report it, you become criminally liable. You know? And there is a punishment for that. So we have to see when omissions become criminally liable. Three principles Ashworth creates, because there is a debate whether omission should be criminally liable, the person should be criminally liable for omission. And if I can't act because I am not physically capable to jump into a pond and save somebody's life. So even if that becomes an issue. So principle of urgency. Sometimes urgency is so acute that person sitting next to you carrying a lot of material which could be harmful to the general health and welfare of the people, and still you do not. Urgency. Priority to life, when life is in danger, you know. So even if you see the right to defense involves defending your life and anybody else's life who is there in your proximity. You have to act. So when the question of life is involved, that's why Michael Sandel comes in picture. He poses some difficult question, whether you will act or not. And principle of opportunity and capacity. You should have an opportunity to act in that situation, and you should be having capacity. This is what Ashworth has formulated. Let us see how this, played out. Should omission be punished or not? This is the question. Rationale of criminalization of obligation, because many people say, there are opponents of Ashworth was of the opinion that omission should be punishable. Whether acts and omissions are equally blameworthy, because generally we think, the general parlance, omissions are not as blameworthy as act. So suppose you act, then you are doing wrong. But when you do not act, you think you are not liable. But this is the question. So in what circumstances should a person said to have an affirmative duty to act reinforced by the criminal law? Please, I think this question must be asked. So in what circumstances? Second, what is the appropriate intensity of criminalization? To what extent it should be punishable? Whether omission offenses are more intrusive than, please read that, than prohibitive ones. So most criminal law is preventive and prohibitive. Criminal law says if you indulge an act of theft, you will be liable for that. So it is prohibitive. But omission offenses are intrusive, means it is forcing you to act in a particular way. So it is against your voluntary will. So suppose you do not act when you are supposed to act. You are not saving the lives of. So whether non-savers are as blameworthy as killers. Ashworth asked this question. Whether non-savers, I mean those who are supposed to save, they are as blameworthy as killers. So killer is killing the person, but non-saver is not killing, but he becomes a factor to kill. So what kind of liability is then, imposed in such cases is the question that the Ashworth is asking. He is a supporter for the punishment for omission, as I said, but he talks of two different views. Criminal law should not punish people unless until there is a clear, serious case. He said this. Secondly, he said social responsibility views. There are times and situations where people help one another, and further says that individuals need others, and people living in the same society does owe some duties to others. He said a very beautiful thing he has explained. He said every omission, causes a duty situation. If there is an omission, means there is a duty. We have to find out whether all omissions may not have a duty situation. If it is so, then probably it may not be criminally liable. But to my mind, whatever is provided in the law, because law is not very clear, I'm telling you, Indian criminal law is not very clear on the subject of omission. Because we have only decorated it here and there, but you will rarely find any omission being punished. Further, three more duties on the list. He said duty to assist those in peril, duty to take reasonable step towards law enforcement. So even suppose you fail to help anybody, means you are like helping a police officer or a law enforcement, and even the giving information to the police officer about the case and all that. So I am coming these duty situations. So Ashworth says these are four very important duty situations where criminal liabilities emerge and where positive obligations are located. So there are family obligations. In family obligation, duty of parents to provide necessaries of life for their children. So even many cases the courts have punished the people where the family members have failed to take care of the elder people, children. So it becomes an offense because you are family obligations under family. Duty of members of household to protect children and vulnerable adults. Voluntary incurred obligations where the possession of hazardous material and inflammable to protect people from danger and to disclose certain information to the government. You are supposed to disclose a lot of information to. So these are the voluntary incurred obligations which you have to. Obligation arising from personal responsibility. This is also very important, like duty of a person delivering from a chosen situation or from non-chosen situation where the one is causally responsible to take steps to deal with danger, like unintentionally causing dangerous situations. If you are not, if you fail to act, you save people in that. And there are also certain civic obligations relating to environment, relating to assisting the government, relating to maintaining so many things, reasonable efforts to ascertain the criminal law. So duty of all person to make reasonable efforts to ascertain the criminal law. These omissions or these duty situations are positive obligations located in criminal law. Where a duty arising from a statute, sometimes duty is arising because defendant was under duty bound by a specific statute, there he has to act. Sometimes he is bound by a contract, you have a contractual liabilities, I am sorry I will not be able to explain it. Then you also have duty arises from a relation I have just mentioned, and there are certain situations, I will just end, that where we find that the Ashworth says that the scholarship in this area is gradually emerging. But he said, Lucia Jedner, responding to Ashworth theory, he said that we are worried about the spread of preventive justice model of criminal law. Preventive justice model of criminal law and positive obligations in criminal law are the two different poles. Most of criminal law, what we notice in our context, is a preventive model, because it declares that if you indulge in this act, you would incur this and this liability. Prevent it, so that you do not indulge it. But one part of criminal law which is largely under oblivion, largely eclipsed, is the criminal law which poses positive obligations on the citizens. With this I end only saying this, that I have not dealt with states' obligation. Probably Mukul is dealing with that deliberately. So there are several states, so all the human rights instruments, international instruments, they cast certain duty on the part of a state to act in a particular way, like torture convention, like juvenile justice, relating standards of justice related. So many conventions have been framed where member states have signed. If a state failed to those, adherence to those, means you are not doing with your positive obligations, which are the part of these conventions. So I think this is very ignored area in criminal law. Why I am fascinated about this, as this particular territory in criminal law creates certain obligations on the part of citizen to act in certain situations. So it is not merely that these liabilities are created when you are acting. These liabilities are also created when you are not acting. Thank you for your attention.